difficult. Personally, I had gone to a number of, at that time there weren't many gay groups. This happened most of the time. But I had gone to a number of gay people and spoken to them, number of people in the community, and at that time they said, listen, we can't put our neck on the line on this one. Maybe you can do it. Nothing will happen to you. But us, we can't do it. So let me tell you, that was the environment at that time. And surely, by 2006, you had groups like Voices Against 377 who came in on the case. But before that, none of these groups were there. And there was only one other group working, that was a known group working with the gay community in Bombay. And I had spoken to them. So, of course, those criticisms have been there. But I think now for us, what is important is, we are back in the Supreme Court. These wonderful guys have all come together, and now we're waiting for a date. The Chief Justice just changed. So the previous Chief Justice, I don't think, wanted to even take this case up because he was retiring. You guys, we're hoping that we get a date soon, because if you look at the arguments that these guys have put up, really it doesn't stand ground as far as I'm concerned, but what do I know? We don't know. The point is that at least the High Court judgment has been such a fantastic judgment, but based on the judgment, I think it's going to be hard to go back on that. But this is between you and me and the world, because one really doesn't know what is going to happen. Thanks.
Sheila from Bangalore, she's in HRLN, and she will talk about the implications of the Vishaka judgment, which I'm sure everybody
does not know about Vishaka judgment. Have you heard? Yeah, all of you know about it, right? So I did not go into detail of Vishaka judgment. Yeah, I'll just tell you, Vishaka judgment is very important in the sense that the question of sexual harassment in workplace came to the mainstream, or came to the notice of the judicial. It came to be sexual harassment. The employer became with the employer of the government that they are culpable, that they have a right to stop the violations of a woman. The violence is a fundamental right. Violence-free life for a woman is a fundamental right of the woman. It came to also become important because of the question of bringing international laws, international conventions to be used by the courts in our country. It also came to make laws, it came to be made as a bill, it came to be, the bill is not in passed, but the Supreme Court judgment laid down guidelines. It became important because that for the first time, the violence against women was taken up seriously, and it was reported in media, and it became also very important because of the question of the rights of women at workplace. So I would say that also I think the most important thing or the best thing about the Vishaka judgment is that groups, people who work with women, people who are concerned about women can come together and access rights for other women who are subjected to violence. So that it came as a public interest litigation, and the groups, various women's groups got together and filed a public interest litigation with reference to a single violation on a woman who was gang raped because she was carrying out a duty as a worker. She was employed by the government, but the government refused to take any kind of action for her violations when she was repeatedly sexually harassed because she was a woman with a woman's body, with a female body. And because of her female body, she became vulnerable. And because in spite of the vulnerability, nobody bothered about her vulnerability or her risks. And in spite of it, she had to bear it. And in the end, she was gang raped. And even though there was evidence, the magistrate threw it because she was a scheduled caste woman, and the Kakus, the magistrate said that Kakus will not be raping a woman who is untouchable. And also it is because the Kakus will not go into a middle-aged woman and rape her. discussion, and it became policy that every public undertaking, private undertaking, any employee, a non-radial employee or a part-time employee or a full-time employee or any employee has a right to complain. And the complaints committee should be constituted by women, more than 50%, and the head should be the woman. The power is given to woman. Of course, it has got a lot of other problems, but I'm not going into that. I would mainly like to come into this to tell you people that from yesterday I've been listening to people about life, there's an invisible line, I find, with my experience. I'm an advocate. I closely work with various organizations in Karnataka. And there's a plot somewhere between activists who are supposed to be pure activists, working for rights of a certain group of people, and the lawyers. I don't say that the fault lies with the lawyers or the activists. I'm just saying there's an invincible block which doesn't make us cross and come together and take full advantage. I'm not saying law or the court judgments is a magical land which the moment you get a court order, all women will get the maternity or the reproductive rights. I'm not saying that. But I'm saying it's a big and important tool, and high time we start using that. Activists should start realizing that they have to use the legal, interventions. They have to get together. We have to get together because the enemy is a big thing. If you want to access rights, you have to take the law into your hands, in the sense, the legal course. And I would say public interest litigation, somebody was saying it's so difficult. For legal intervention, because public interest litigations are difficult, far from it. I found that I used to have a very big block, go to high court with all those black coats and black gowns, but I found it's very easy. You just have to state facts, and you just ask for prayers, and you have any petitioner. You just take your neighbor who doesn't know anything, put that person's name, and just go to the court. So it's not at all difficult. I would say courts are the best access to everything. So brings the violation to mainstream. All of you are speaking. Yesterday, Dr. Prakasham was saying, after 2.5 lakhs, wow. After 2.5 lakhs, campaign has to start. After getting the order from the court, you have a legitimate campaign which you can go through. You can go through that. Then there were people who were saying we have been coming across these kind of violations every day. We have seen 500,000 of women dying. So what are you doing about that? Why are you keeping quiet? Now brings the violation to mainstream in the sense it can contact media people. You bring it, the moment you file a case, you give publicity. Like she was saying, publicity people started talking in their grand rooms. So this is important that it comes to international forums, to other forums. Then personally, I just spoke about issue to IFPI, and then the brings into violation after discussion in various groups. Just don't stick to people who are working with reproductive rights. Work with other people. There are groups and groups. Work with disability groups. Work with other people who are working with homosexuality or whatever. We have tribal groups, Dalit groups. We now, the NGOs have started, having groups separated. Please don't do that. Get into this, any issue. See that other people are also involved, because it is true, a woman is there anywhere, and the reproductive rights of women in any group is a fact. When it comes to the access to remedies, once you get remedies is easier. I'm not saying I'm repeating, it's not so easy, but somewhere it is much easier if the court order was not there. It's easier to have a court order. Then we should facilitate implementation and campaign. Campaign to start a campaign, to give a lecture, and I'm sure the High Court order should be campaigned all over the country. It should be told to people. We are thinking that you can't be only for the upper class people. This is valid for the people who are on the grassroots level, ground level, people who cannot have a BPL card, who do not have a BPL card, that they don't have to have a BPL card. It's a tremendous thing to know. And what are we going to do about that? That's most important. So that kind of thing, you got it through the court order. You imagine what we want. It's fantastic because I know how it is if you don't have a BPL card. And this this has come through the court order, would have never come to anything else. Court, and then going through legal process, and then can be taken up by other states and Supreme Court. Just like now we have a High Court order, maybe we can go to Supreme Court on that, say that this policy should be laid down for all the states. Maybe we can go, each state can find such cases. Each state will have people like the lady who died, whom they showed yesterday. So I would say that this forum, here we have such learned people, such people who have so much knowledge and experience. I think this whole workshop is to think about legal intervention, and I think you should go in that direction. And use the law as a tool, apart from other tools. I'm not saying it is going to give you 100% answers. It takes a long time, a long struggle, but it's like any other struggle. Nothing can come in 1 or 2 days. But then I think it should be used, and we have so many lawyers who can do it.
What should be our legal intervention? Considering the fact the reason why we had this session was to explain the development of law with regard to 1377 and also with regard to Vishaka judgment, which basically broadened the definition of article. Of course, there were many other articles and laws considered, but it broadened the definition of Article 21. In the case of 377, it dealt with the issue of privacy. In the case of Vishaka, it dealt with the issue of right to a safe and healthy working environment and the right of a woman to live in dignity. So these were the basic issues that were dealt with and developed, and of course the definition of sexual harassment was broadened and made much more really broadened to include hostile environment as well as sexual attacks. So and these are laws which we can have the judgments which we can use in our day-to-day work when we deal with health issues. So if people could talk in terms of what we discussed yesterday as well as what we discussed today, in terms of what our legal intervention could be in respect, taking into consideration these two judgments. So I open the house for a discussion on this.
But this is in addition to what Anjali has spoken. It's been a hectic time, like past 10 years, though Anjali took up this issue. Earlier to that, maybe she might recollect the visits that she had been to Bangalore with regard to the groups that she met, and one was one of our groups that she had personally met. And it was such a tough job even to meet group people, to say it was a hectic job. And to meet and join, we had to whisper, sitting in one corner of a coffee shop, and we had to whisper to each other. And it was such a pathetic situation that, the non-Jews who used to frequently visit, they used to just say hi and sit along with us. And it was really not in a way to continue there. And, we had to hire some place that,